I heard the court ask us to discuss irreparable harm, and I didn't hear anything about irreparable harm other than.
We'll now go to page 31, Association of Public Safety Officers versus Las Vegas Review Journal.
Your Honor, William Schuller and Nick Wieczorek on behalf of NAPSO and its affected members.
Good morning.
Good morning, Your Honor. Joel Tasca and Matt Cate on behalf of the Las Vegas Review Journal.
Good morning, Your Honor. I just want to let you know, Wade Doctor on behalf of the City of Henderson. We've moved to intervene. We haven't gotten an order yet. The hearing is Thursday.
I believe I set the order shortly time for
Yes,
Thursday.
for Thursday, you did, Your Honor. So I wasn't sure if you wanted me to be a participant or not at this stage because we're not technically a party yet. So I just thought I'd make my appearance for the record.
In response to that,
We have no problem. We plan to oppose the motion. And Your Honor, I have one other housekeeping matter when we resolve this one.
okay. So I'm not sure.
If the City of Henderson wants to move forward with its motion today to join, that's fine. We will oppose it today.
Well, we can certainly wait until Thursday, Your Honor. I just didn't know what, if any, participation I would have here today. I just want to make sure that you know my presence is here.
Yeah, I'm not going to hear the
There's
motion
questions
for
on
intervention
the
at this time. I set that for Thursday. I'll hear it then. But you have no objection to Mr. Bachner participating in this hearing today?
No objection, Your Honor.
Okay.
Thank you.
Then, Your Honor, my other housekeeping item is that Mr. Cate is from out of state. He submitted his pro hoc vice motion to the Bar Association, which, we didn't have a chance to get going on until we got this, given the emergency nature of it. But that's in process, and we spoke with opposing counsel. They have no objection to Mr. Cate arguing, so if Your Honor is okay with that, he's going to argue the
If
motion.
there's no opposition by opposing counsel, I have nothing in the record yet to show that motion hasn't been filed yet, so I haven't received any input from the state bar. Okay, but I'll allow participation based on the non-objection by counsel.
Thank you, Your Honor. Thank you, Your Honor.
Okay. So this is pursuant on order shortening time, right? And all I'm hearing today is the application for a temporary restraining order. I'm not hearing an application for preliminary injunction, just a temporary restraining order, and that was set out in the order shortening time solely on the application for temporary restraining order. So when I'm considering a temporary restraining order, I'm not addressing reasonable likelihood of success on the merits. I'm looking at irreparability of injury. Okay. When I hear the motion for preliminary injunction, I'll hear irreparability of injury and also reasonable likelihood of success on the merits. Okay, so the focus should be on irreparability of injury today. Okay.
Thank you, Your Honor.
And on a restraint. I don't do mandatory restraining orders. I do restraining orders. Okay.
Understood. Your Honor, while it's unfortunate that we're here this morning, as far as injunctive relief goes, I think this is as straightforward an issue for the court's consideration as you can get. We're here because of an article that the RJ published on September 20th in its online version regarding overtime pay at the Henderson Detention Center and Henderson Corrections officers working at the detention center. That article is entitled, "Henderson Jailers Get Millions in Overtime But Still Make Critical Mistakes." Again, originally published online September 20th. The print version was published on Sunday on the front page with one of the pictures in the interior of the paper. Now, the problem with the article isn't the substance, the content, or the written portion of the article. The problem with the article is that it includes a video, large portions of which are surveillance footage at the detention center, and 6 photographs of officers working at the detention center, which for all intents and purposes appear to be still shots taken from that surveillance footage. Now, that video and those photos are problematic because they fly in the face of the subject statute. Now, that statute's NRS 289.025, subsection 1 states, and I quote, except as otherwise provided in subsections 2 and 3 and NRS 239.0115, the home address and any photograph of a peace officer in the possession of a law enforcement agency are not public information and are confidential. So there are 3 exceptions to that first subsection, right? The first is the reference to NRS 239.0115, and that regards an application for public information that's 30 years plus old. Obviously, that's not the case here. The other 2 exceptions are in subsection 2 of NRS 289.25. One is if the peace officer, him or herself, authorizes the release of the home address or the photograph, or 2, if the officer depicted in the picture was arrested. And neither of those exceptions apply here either. I'd like to just read a couple excerpts from the legislative history of the statute, which I think are helpful here. One is from the Nevada Assembly Committee on Judiciary minutes from March 23rd, 2005. In discussing this statute, the committee and others present in front of the committee specifically discussed the safety concerns of officers in regards to this statute. Mr. Gary Peck, director of the ACLU of Nevada, he stated, and I'm quoting here, "The only other problem has to do with the confidentiality of officers' addresses and photographs. I want to make sure there's no confusion about this. If a newspaper takes a photograph of a police officer, they can obviously publish it. Also, there's a home address issue. I think there's a legitimate concern among police officers and their home addresses not be freely circulated in a way that will put their safety at risk. I have no problem with that and no problem with balancing that with the public's right to know what their police department and officers are up to." Discussion followed regarding safety concerns, and similarly, at the Nevada Senate Committee minutes of, the 74th session, 2007, Nevada Senate Committee minutes, May 4th, 2007, there was a guest legislator present, and that was Assemblyman Marcus Conklin from Assembly District number 37, as well as a Mr. Chris Collins on behalf of another local police union. And they discussed safety concerns underlying the statute as well. Per Mr. Conklin, Assemblyman Conklin, Assembly Bill 50 is a compromise piece of legislation. In the 73rd legislative session, we passed a police officer's Bill of Rights, and in almost every iteration of that police officer's Bill of Rights, it addressed the privacy of an officer. Assemblyman Conklin goes on to say, "The revision of Assembly Bill 50 has been narrowed in scope on a compromise between the Nevada Press Association and the Las Vegas Police Protective Association." So there was input between the press and the local unions regarding the verbiage in this statute. Now, Mr. Collins went on to state that he believed it was vital to the families and safety of our officers and asked for the support of passing the bill to help protect other officers in Nevada. So I just think it's important to note the public policy underlying the statute at issue here. It appears that the only Nevada Supreme Court case providing any substantive analysis of the statute is Conrad v. Reno Police Department. And that decision was issued only 3 months ago, June 15, 2023. In that matter, an individual who ran an online news website had requested some documents through the Nevada Public Records Act, requesting records as well as unredacted body-worn camera footage. The Nevada Supreme Court agreed with the district court in that the trial court found that while body-worn camera footage constitutes a public record under NRS 289.832, an officer's photograph is indeed confidential under our statute, NRS 289.0251. There, the district court applied this protection to the faces of officers in the body-worn camera footage. District court also reasoned that, quote, a video is merely a compilation of photos and is therefore subject to the confidentiality provisions that certain photographs receive under NRS 289.0251. So clearly here, we have a video and we have photographs. Both are subject to the statute, right? The Conrad court went on to hold that the district court correctly denied the petitioner's request as to the unredacted body-worn camera footage. In so doing, the Nevada Supreme Court held that the language of NRS 289.025 is unambiguous. It stated that, it held that any record produced from body-worn camera footage is subject to both the NPRA and any confidentiality provisions limiting public disclosures. Reading the term photograph in context supports the conclusion that an officer's face as it appears in body-worn camera footage is confidential under NRS 289.0251.
So that was, the context of that was pre-publication, pre-dissemination, right?
That's correct, Your Honor.
In this case, we have publication that's already taken place, right?
Correct, Your Honor. However, I think what's important to note there is that the Conrad court engaged in a balancing act between the public's right to this footage, this unredacted footage, versus the underlying purpose of the statute, which is to protect officers, their photographs and their home addresses under our statute. Now, as to, I know Your Honor wanted to focus on irreparable harm. In their opposition, the Review Journal states that, well, there's been no representation that any officer has been threatened or harmed as a result of this article being published. Well, first, we don't know definitively what steps anyone reading this article may have taken. But however, irreparable harm in and of itself isn't the factor. The factor is the probability or threat of irreparable harm. Now, since the article has been published, each day that goes by, that threat grows. I mean, there's, in addition to the 331,000 followers on Facebook that the RJ has, the opposition makes clear how many times the article has been reproduced, links to the articles, etc. Between that and the fact that it remains online, accessible to anybody with a subscription, has unlimited access to the article. Anybody without a subscription can also access the article because they have up to, I believe it's 5 free articles per month. Just increases the probability of irreparable harm each and every day that it remains published online.
And of course, we're not dealing here with any address information or anything like that. We're just talking about pictures, right?
Correct, Your Honor. There's no issue as to addresses. However, the article does reference several officers' names in the body of the article. We don't know, and even if we did, we wouldn't represent whether or not those names correlate to any of the officers depicted in the video or the photos. But names are in there, not addresses. Now, we know that the video that the Review Journal received, it came from somebody at Henderson PD, or at least we're reasonably certain that it came from somebody at Henderson PD. Now, I think it's the very first sentence of the opposition, or at least the introduction and summary of argument in the opposition, states that the Review Journal lawfully obtained truthful information about issues of public concern. Well, if it came from somebody at the Henderson Detention Center, it's not lawfully obtained information, because whoever that individual is, he's a confidential source, ironically, for the Review Journal. They had no right to provide this surveillance footage to the RJ. They didn't have the officer's consent, and those officers weren't arrested. So the information was obtained unlawfully in violation of the statute. Okay? Furthermore, we know that there's no problem in redacting these officers' faces because the video that is attached to the online version of the article redacted one of the detainees' faces or upper body, and I can represent to you that my colleague, Mr. Wieczorek, and I had a phone conversation with Brianna Erickson, who is the author of the article, last week, and she confirmed to us that the RJ took it upon themselves to make that redaction in the video because the detainee in question had a tattoo of a swastika on his back, I believe it was. So we know the RJ took it upon themselves to redact that portion of the video. However, they're refusing to redact the portions, the faces of the officers depicted in that video. Furthermore, since the article was originally published, the city of Henderson themselves took it upon themselves to send the RJ a redacted version of this video, whereby the corrections officers' faces were redacted. The city of Henderson did the work for them. The RJ still refuses to alter the video associated with the article and leaves it as is. Now, any argument that our request here, which is pretty minor, we're just asking that the portions of the video and the 6 photographs depicting the officers be redacted as to the faces. Any argument that that has some kind of prior restraint or constitutional impact on the review journal is hard to take seriously when, one, they already took it upon themselves to redact portions of the video, and two, if you redact the officers' faces, it has no impact whatsoever to the substance or the content of that article. We're not asking them to take the article down. We're not asking them to alter any of the viewpoints set forth in that article. And the corrections officers depicted in the video are wearing corrections uniforms. So anybody looking at the video or the photographs, if it's in redacted form, they could still tell that these are the subject employees at the detention center based on their uniforms. You don't need to show their faces as well. So there's almost no onus on the review journal to make these changes. As I mentioned, I had a conversation with Ms. Erickson last week. She called for commentary regarding an article on this lawsuit. Thereafter, the RJ published an article on this lawsuit, and adding salt in the wound, so to speak, again, they included a video, the same surveillance video, and one of the 6 photographs of these officers, despite already having in their possession the redacted copy of the video that the city of Henderson provided to them. So it's almost no, I don't want to throw out the word hypocritical, but here we have the RJ protecting its confidential source, and rightfully so. In recent memory, we have the RJ engaging in quite a prolonged litigation battle with Metro over the confidentiality of its sources on Mr. German's the electronic devices, and rightfully so. We have the RJ redacting an inmate's tattoo that it finds offensive, but for some unknown reason, it refuses to show the same level of respect for the confidentiality and safety of our public officers. There was a supplement filed this morning. We would argue that supplement's untimely, given that we didn't have a chance to file a reply, but regardless, the supplement talks about, well, first it says that NAPSO has no standing, that the officers themselves would have to bring this action. NAPSO has associational standing here. We've confirmed that the officers depicted in the video and photos are in fact NAPSO members. So that addresses that argument. Also in the supplement, there were representations made regarding certain public events or community events that certain Henderson officers participate in, whereby they either are interacting with the community directly or their photos are depicted online or in print. That's neither here nor there, given that those officers consented to having their likenesses published or interacting with the public. Again, that would fall under one of the exceptions of subsection 2 of our statute. I don't have much more to add, Your Honor, unless you have any specific questions. I know we're only dealing with or focusing on one of the 4 factors, but I would represent that in the event that Your Honor is inclined to grant the temporary restraining order, and I have a proposed order here, I don't see the need for further briefing to have a second hearing on a motion for preliminary injunction. I think that what we're here today on is 2 interpretations of the same statute that the Nevada Supreme Court has already held is unambiguous. And if Your Honor is inclined to agree with our interpretation of that statute, then I think it's clear that the Review Journal is in violation of that statute, and the violating video and photos need to be altered. One other argument they made is that the statute only applies to, I believe they said, governmental agencies. Nothing in the clear, unambiguous language of the statute that says that. In fact, there's nothing in NRS Chapter 289 that says that. If that were the case, it would hamstring the entire purpose of the statute, which, as I discussed earlier in reading from legislative history, is to protect the safety of these officers and their families. So I don't know where they're getting the fact that they think they're not required to follow this clear, unambiguous statute. Thank you.
I don't believe there's any contention being made that any of these police officers are undercover.
Correct. That was another. Thank you. That was another point I wanted to make. They argue that there's no representations made in our briefing that these are undercover or vice officers that would need special protection. Again, the plain language of the statute says it applies to all officers. It doesn't narrow it to patrol officers, corrections officers, vice officers, or anything else. It applies across the board to officers.
Okay, so specifically, what are you seeking relative to redaction?
We would ask that the video be redacted in the same manner that the inmate's tattoo is redacted, that is with square blurs on each of the officers' faces.
What about the back of the, most of the pictures I've seen are from the back.
Well, anything neck and above, we would ask that it be similarly redacted, just like the inmate was. And by extension, to the extent there were still shots of that video, the still shots of that video would have to similarly have those square redactions. Again, a pretty small ask.
All right, thank you.
Thank you, Your Honor. Matthew Cate for the Review Journal. Appreciate you allowing me to appear. Appreciate counsel's indulgence as well on behalf of the Review Journal. And I'd be remiss if I didn't point out that we have some representatives from the Review Journal here today, signaling the importance of these issues. We have Mr. Ben Littman, counsel for the Review Journal in-house. Mr. Glenn Cook, the executive editor, is here as well. And Ms. Erickson is working hard covering these proceedings as well. I heard the court ask us to discuss irreparable harm, and I didn't hear anything about irreparable harm other than a non-particularized fear that something may happen. The cases we've cited in our papers explain that to issue the temporary restraining order of a mandatory nature that the court has indicated already that is disinclined to issue, there needs to be, and the court needs to provide from the record, articulable facts showing the specific harm that will result, that's the language, will result, if the court does not issue its temporary restraining order that NAPSO is requesting. There's no such evidence in the record whatsoever. We have assertions by counsel that don't have foundation for his generalized fear that something may happen. And in fact, it has been 12 days. I would submit that rather than the threat increasing as time passes and nothing happens, that in fact the fear should diminish. And there's nothing in the record that should suggest otherwise. And in fact, I do think the fact that the Henderson Police Department is interacting with the public, presenting its officers to the public, I think that's a laudable goal. The community wants to know its police officers, wants to see them in public, also wants to watch them carry out their public duties. So what NAPSO is representing and basing its irreparable harm theory on is the fact that danger depends on who does the disclosure. If the Henderson Police Department or if the officers themselves consent to having their images and their names with their images released to the public, no harm. But if the newspaper obtains, lawfully, I'll get to that in a second, lawfully obtains information that may identify police officers, that's somehow a threat. There's nothing in the record to support that, and there's nothing, and that's what I heard the court say, please discuss irreparable harm. I've not heard it, I've not seen it, it's been 2 weeks. And that factor alone, and I would like to have the opportunity to address some of the merits-related conversations and arguments that counsel made related to the statute, because there is some overlap with the harm showing. But that irreparable harm is simply not present here. And to step back and look at, temporary restraining order, as the court's indicated by its disinclination to issue mandatory orders, is already an extensive, heavy burden on NAPSO here. There is the overlay of the First Amendment concerns of the prior
Well, I do
restraint.
consider mandatory orders on motion for preliminary injunction, but not on temporary restraining order applications.
You do
Restraining
not,
orders are to restrain, not mandate, so.
right, and what's being asked here is to ask the Review Journal to take down a presentation of news and information that in its editorial discretion has decided to shape the way it decided to shape it. And that is the province of the newsroom, not with respect the courtroom through NAPSO asking the court to dictate how that presentation occurs. The First Amendment is designed to protect the free flow of information from the people who have it, people who need it, which is the public. And that's an important principle of self-governance, representative democracy, is that the people need to be informed as transparently as possible. And the press, their role is to take that information and exercise its editorial discretion and provide it to the public. And what Your Honor is being asked to do is to tell the Review Journal, take the copy that the NAPSO is giving you, or that the city of Henderson is giving you, and why don't you present it the way they want you to? And that would hinder the transparent representation of the article. Full transparency to the extent possible is the goal of the press, and that would undermine that. And it would require, it would mandate that the Review Journal take this down and speak in a certain way. The Supreme Court of the United States over and again has held that courts cannot impose that type of prior restraint before there's an ultimate determination on the merits of whether that publication is lawful. Again, we have a lot of arguments on the merits, but to discuss this mandatory nature of what the court is being asked to do, you're being asked to make us take down a publication, replace it with something else. That's dictating how the Review
I think
Journal.
what they're saying is restrain, arguably they're saying restrain it in its present form. It can go forward as communication, but make redactions of basis.
Well, in the redactions, but that's deleting content, Your Honor. All the cases that deal with prior restraint are about focusing on the allegedly harmful content and allowing the rest to stay up. For example, Smith versus Daily Mail, I think, has application across several aspects of the analysis in front of the court today. There you had a West Virginia statute that criminalized the disclosure of the name of a minor accused of crime. And in that case, a West Virginia teenager shot and killed a classmate. Through normal reporting techniques, the newspaper obtained the name and published it. They were indicted for doing so. And the Supreme Court said, the statute says you may be punished criminally for doing that, but that statute cannot stand under the Constitution because you have a right to disseminate that information of public concern. And the issue there was, don't reveal the name. You can report, as the newspaper did, about the shooting, about the impact on the community, but don't report the name or we will hold you criminally liable. Also, getting to irreparable harm, back to that notion, the Nevada Supreme Court about 5 years ago dealt with a prior restraint issue with the Review Journal, where another department of this court issued a temporary restraining order, to prohibit the Review Journal from publishing an autopsy report. that the newspaper obtained through public records requests. And the newspaper had reported on those, as did the Associated Press, other media outlets. It was about the mass shooting from several years ago here in Las Vegas. And a family member of one of those victims tried to say, please stop the publication of these autopsy reports. It was ongoing. It had already been happening. You're violating our family's privacy interests. And that prior restraint was issued. That the district court said, take that down, remove that autopsy report. And the Supreme Court of Nevada said, absolutely not. You have to keep that up. We sympathize with the family, but the free flow of information, the prior restraint jurisprudence that goes back decades, if not centuries, in this country said, you can't tell the newspaper to take it down, especially when, as we have here, the information is already in the public realm. NAPSO has acknowledged that potentially thousands of people have seen this video. It's been posted for 2 weeks. The Nevada Supreme Court, in the prior review journal, prior restraint case, said once the toothpaste is out of the tube, cat's out of the bag, conjunctive relief cannot issue to solve that problem if there even is harm. There's no harm here, but now it's already out. The Nevada Supreme Court says that a prior restraint, a restraint or an order to take it down can't apply. Additionally, Your Honor, I do want to speak to the statutory framework that NAPSO invoked in discussing the harm here. The Peace Officers' Bill of Rights, as they mentioned, is where this statutory provision comes from. Section 289.025 is part of Chapter 289. That legislation, as the Nevada Supreme Court has held, is supposed to govern and does govern the rights and duties between the peace officer employees and the governmental agencies that employ them. That framework, as the Supreme Court, Nevada Supreme Court in Bish versus Las Vegas Metropolitan Police Department, that's 129 Nevada 328, has held that this framework of the Peace Officers' Bill of Rights is to govern the duties of employers. I emphasize it that way because the Supreme Court of Nevada italicized it itself. That's what this framework is about. It has nothing to do with the press. If it can't be applied that way on its face. The statute does in fact say that this is about photos and home addresses, quote, in the possession of a law enforcement agency. And when can those photos be disseminated by the law enforcement agency? Well, various factors, consent and things like that. But that is directed to, on its face, law enforcement agencies. In its framework, it's directed to law enforcement agencies. And so the statute doesn't apply, cannot be applied to the Review Journal. And even if it were construed to do so, the Daily Mail case that I referenced in the West Virginia statute, the Supreme Court, in a line of cases flowing from that one, has held that criminal prohibitions, liability prohibitions against the press, when they're written into statute and they prohibit the dissemination of public information, they are invalid. They are constitutionally infirm, cannot be applied to restrict that information and that publication. And so I apologize for getting into the merits. I know the court didn't want to hear that today, but it was brought up, it was mentioned, and this statute doesn't apply. That also goes to the harm. The harm that the statute addresses is disclosure by the employer. It doesn't go to the disclosure by the Review Journal. And, I have mentioned the prior restraint. The court, of course, is aware that the burden already placed on a party seeking a TRO. It's made all the more difficult to obtain the prior restraint against the press. It's never been affirmed by the court. It's hard for me to tell the court what is appropriate and when it passes the test because it's never been done. Time and again, the court has held you need to justify a prior restraint that prohibits or takes down public information that the press has reported of public concern. You have to do it in service of a state order of the highest interest. And, the Nevada Supreme Court, in the case that I referenced earlier involving the Review Journal, calls it necessary. You have to have a temporary restraining order, prior restraint, to prevent an evil of the gravest nature. The Pentagon Papers was revealing and reporting on military analysis, top secret analysis allegedly obtained in violation of the Espionage Act. And the Supreme Court said, we cannot prohibit that publication. The interests, the Supreme Court in the Review Journal case, the Nevada Supreme Court in the Review Journal case I referenced, the court sympathized with the family of the shooting victim and said, we appreciate the distress that this may cause you to see this information about your loved one out in the public. But this standard is so high, we cannot allow this information to be taken down, this information to be redacted from the public record that's been put out there. And so, that other layer, must be satisfied by NAPSO, and they've not shown anything equivalent to the type of harm that the Supreme Court has hypothesized as sufficient. One of the concurrences in one of the First Amendment cases talks about maybe troop movements. Prior restraint could be issued to stop troop movements or prevent a nuclear holocaust. It's that serious. And speaking of irreparable harm, all of these prior restraint cases explain that the restraining and the requirement to dictate what the press can and can't say, a moment's issuance of such an order is irreparable harm, not just to the speaker, not just to the press who's being restrained, but it's irreparable harm to the public that relies on the press to obtain that information. And I do need to emphasize a point. NAPSO has discussed that there's a potential violation of this statute by someone's disclosure of information. There's no allegation that the newspaper itself did anything other than receive information. The Supreme Court has over and again held that the receipt of information by the press, it doesn't matter. Whenever you receive information of public concern, it doesn't matter if a source violates the law. It doesn't matter if there's a prohibition on disclosure. Daniel Ellsberg was accused, of violating the Espionage Act. The New York Times and the Washington Post were free to publish. Likewise, Bartnicki versus Fopper is a more recent case where someone illegally recorded a conversation, violating federal and state wiretap laws, released that recording to a radio station, and the Supreme Court said you can't impose liability on the press even if someone else acted unlawfully in giving them information. And so, whether someone's violated the statute that regulates the rights and duties of employees and employers in peace officer settings has no bearing on whether the Review Journal had done anything unlawful. They did not. They published public information. That's always going to be protected. Court's indulgence for just a second. The Conrad decision in the public records case, counsel's correct. The Nevada Supreme Court said that this confidentiality provision requires that, or doesn't, the confidentiality provision that's at issue in this case allows the police department to withhold this information. And the statute does seem to say that the law enforcement agency cannot publish that information in response to a public records request. But that doesn't have anything to do with whether once it's obtained in other means, that information is a public concern and may be distributed. Once again, the legislature can try to say, I don't think it's important for the public to know this. I want the public not to know this. The legislature can try to say that. But you have that First Amendment principle that the Supreme Court has repeatedly applied and said, whenever you make that determination, it has to be constitutionally valid. It has to serve and not disrespect that free flow of information that the First Amendment protects. So West Virginia Mail, you had a Smith versus Daily Mail. The court invalidated a West Virginia statute that clearly prohibited publication by the press of a minor's name. We didn't have the ambiguity that is present in this case. In fact, I don't think it's ambiguous at all. The statute is very clear. It doesn't apply to the Review Journal. In Smith versus Daily Mail, there was no dispute. You can't publish this information. The Supreme Court said that's invalid. Florida Star versus BJF. The newspaper was sued over a statute that prohibited publication of sexual assault victims' names. A similar provision in Georgia has been struck down by the Supreme Court, where we were prohibited criminal sanctions for reporting the name of rape victims. Over and over and over again, the Supreme Court holds that the First Amendment finds application of those types of statutes constitutionally invalid. So, if the court were to issue the relief that NAPSO is seeking today, it wouldn't solve any harm against the police officers. There's nothing in the record showing that there's harm. And instead, it would wreak serious harm to the public and to the press. And with that, Your Honor, I mean, I'm happy to answer any questions, or otherwise, I'm happy to listen and take any further direction from the court.
Okay. Response?
Thank you, Your Honor. It wasn't the receipt of the surveillance video that caused the Review Journal to violate the statute. It was the subsequent publication of that video making confidential information public information. As to irreparable harm, right before I came in here, and you may see we have several officers present, I was informed that several officers depicted in the surveillance video have been asked by their neighbors, hey, was that you depicted in that article in the RJ the other day? So people are making the correlation. So the notion that the harm or the probability of harm is decreasing is just wrong, especially when you consider the fact that not only do we have the original article, we have the second article that came out on Friday, which I discussed earlier, discussing this lawsuit, reproducing the same video in one of the photos. And obviously, given the media's presence here today, we're going to have at least a third article, which we have no reason to believe won't include the video and or pictures still shot from that video. Counsel argued that altering the video with the redacted faces of the officers would hinder the full transparent nature of the article. Well, that's already occurred given the redaction that took place regarding the detainee's tattoo. So either you're going to publish the full article and make that, the full unadulterated version of that surveillance footage, or you're not. Don't redact parts of it and then say, oh, redacting other parts of it is going to hinder the full transparency. And regardless, redacting the tattoo or redacting the faces has no impact on the transparency of the article. The article's full content is not one word in that article is affected by the relief requested here today. As to the autopsy case that counsel discussed, that report came from the city itself. Whereas here, we have a confidential source who provided the video to the Review Journal, who was unauthorized to do so and did so in violation of a statute. So, I mean, it's the RJ's unclean hands in publishing surveillance footage that should not have come into its possession in the first place, refusing to change it when notified of the violation, and when given a redacted version of the video, and the continuing harm that is taking place given the several articles now that are out there depicting this video and photos, that's the basis for the order to redact here today. We should not have to wait until an officer is actually physically harmed or the officer's family is physically harmed before we should come before this court requesting the relief we are here today. Again, this is such a minor burden, I hesitate to even use that word, on the RJ to redact these faces. They've gotten the version of the video that they need to put up there, and in doing so, it does not run any risk of journalistic integrity, transparency, or whatever other word they want to throw out there. All it does is serve the purpose of the statute, which is the safety and the anonymity of our local officers.
As I indicated, all I'm hearing today is the application for temporary restraining order. It's on an order shortening time. This is going to have to be further developed on the motion for preliminary injunction, which I wrote here on the set for October 16th at 11 a.m. Okay? And I'm going to call for supplemental briefing. Again, this is on an order shortening time, so the defendant did not have a full opportunity to oppose, and that's why I didn't put it on for hearing on the motion for preliminary injunction today. So I want the defense to submit their any supplemental opposition, and I haven't looked at the supplemental opposition that was filed yesterday, apparently on October 1st. I've been on the bench all morning, and I haven't had a chance to see that, but I'll give you an opportunity to supplement your opposition now to the motion for preliminary injunction. Get that in by close of business on October 9th, and I'd like to get the supplemental, reply to opposition in by close of business on October 13th, okay? And in the meantime, having looked at it just from the standpoint of irreparability of injury, I'm not persuaded that I should issue a temporary restraining order. And that's without prejudice to your contentions on the motion for preliminary injunction, okay, once as it's further developed, okay? But at this point, I just can't, I just don't see the warranted showing of irreparability of injury, so I'm not going to grant a temporary restraining order. Again, without prejudice to your contentions on your motion for preliminary injunction. At that time, I'll be considering both the concept of irreparability of injury and reasonable likelihood of success on the merits, okay, and the other aspects of preliminary injunction, okay? So I need a proposed order. I'll ask defense counsel to submit a proposed order and run it by plaintiff's counsel. Again, I'm not making any determination now on the preliminary injunction aspect. I'm just considering it as a TRO, and so be it. Okay.
Thank you.
Thank you, Your Honor.